Great. Good morning, everyone, and thank you for joining us today for our webinar, Letters of Intent and Confidentiality Agreements, which is part of our BLG Driven by Women three-part webinar series. And this is the last one. So if you missed the first two, they are available on our website. So I encourage you to go find those as well. Today we're going to be using the chat and the Q&A features, so please click on those icons at the bottom of your screen and have those open and ready to type in your questions as they come up. And we will be monitoring those as we go through the session today. So briefly, my name is Kerrilee Auger. I'm the Skills Development Manager here at Women's Enterprise Center, and I work out of our Kelowna office. I have the pleasure of overseeing all of our training programs, including forums such as this, additional webinars, phone-in sessions, and live workshops. So if there's a topic that you would like us to consider for the future, please be sure to complete our follow-up survey and share your ideas. And Women's Enterprise Center is a nonprofit organization devoted to helping women in BC start, lead, and grow their own business. Our full range of services includes business loans of up to $150,000 with access to an additional $100,000 through a partnership with BDC. And we also do joint loans with Futurepreneur and Community Futures. We also provide business advice, skills training, mentoring, resources, and a supportive community to help women entrepreneurs realize their business potential. And we do this from our three offices located in Kelowna, Vancouver, and Victoria, but we serve the entire province. And our passion is to empower women entrepreneurs to their business success. So we're funded by the federal government through Western Economic Diversification and are part of the Women's Enterprise Initiative, which includes similar organizations in Alberta, Saskatchewan, and Manitoba. And of course, you can learn more about us and our services at wec.ca. So today's session, Letters of Intent and Confidentiality Agreements. To answer your questions and provide us with valuable tips and resources, we're very excited to have with us Michelle Wilkinson and Brianne Lahody of Borden Ladner Gervais in Vancouver. And today they're going to outline some of the key aspects of confidentiality agreements, letters of intent, and provide two important tools available to businesses when first entering into any commercial agreements. So this is going to help you understand the context, timing, and scope of each of these tools to ensure the best outcome for your business. So I'm pleased to hand it over now to Michelle and Brianne. And if Michelle and Brianne, you want to introduce yourself while we do the quick swap and you pull your slides up, that would be great.
Sounds good. Good morning, everyone. So welcome and thank you for attending our talk today on confidentiality agreement and letters of intent. So as mentioned, my name is Michelle Wilkinson and I'm here with my colleague Brianne Lahody, and we are both lawyers here at BLG, and we work on the securities team. So we generally mostly work with public companies, so companies listed on the stock exchange, and we do some work with private companies as well. And we help them with a number of things, but mainly we do transactional work. So we do things like buying and selling businesses, reorganizations, we help our clients raise money, and we also do a lot of general corporate and securities advising to just ensure that our clients are complying with laws. And we are also both proud to be part of the Driven by Women initiative that we have here at BLG. And Brianne is going to talk a little bit more about that program so that you guys are aware of it. And then we'll get into our talk on the confidentiality agreements and letters of intent.
All right, good morning, everyone. So as Michelle mentioned, we just wanted to tell you a little bit about Driven by Women, which is a BLG initiative we're both part of, and which this presentation is being put on in partnership with Women's Enterprise Center. So Driven by Women is tailored to meet the needs of female-led and female-founded companies. We partner with female entrepreneurs who have founded or led businesses with a developed business plan, existing funding or annual income, and plans for scaling up. What we do is we host community building events where we share helpful information and foster a supportive and collaborative network where female entrepreneurs can gather to meet, learn, and share. We offer a full range of services from leading lawyers and professionals, including mentorship and advice based on our unparalleled depth of experience, Michelle and I in particular, and then flexible fee arrangements. So along with negotiated arrangements, we offer set fee packages to make starting a company as quick and painless as possible. So that's a little bit about Driven by Women, and on to our topics for today. So as mentioned, we're going to be talking about two different types of legal documents, confidentiality agreements and letters of intent, often called LOIs. So these are two very important legal documents to think about and consider when you're first entering into any kind of commercial transaction or even business relationships in general. They're two of the first written documents that the parties will turn their minds to, and two of the most important, although often overlooked. So confidentiality agreements, sometimes called non-disclosure agreements, are, I'm sure a lot of you are familiar with, but they're contracts between two or more parties, the subject of which is a promise that information that is shared between those parties will be kept confidential. And the scope and meaning of that definition we'll talk a little bit more about in the rest of the presentation. And then LOIs are documents outlining the understanding between two or more parties, which they intend to formalize in a legally binding agreement later on. All right, so we're going to address confidentiality agreements first. And we wanted to start off this topic by just pointing out something important to note, which is that there is a legal obligation to protect confidential information at common law. And what that means is that this duty exists even without a confidentiality agreement. So if information is conveyed between two parties that's confidential, if it's communicated in confidence, and then if it's misused by the party to whom it was communicated, or the receiving party, we sometimes say, then you may be found to have breached a duty of confidentiality, even if there is no written agreement or understanding between the parties. And this duty or obligation can arise even if the misuse of the confidential information doesn't result in pecuniary loss. So what that means is a loss that can be measured in financial terms, or more easily measured. So even if someone misuses your confidential information and you can't necessarily point to a financial loss, they still may be found liable, and vice versa. The common law duty of confidentiality is very broad. It's potentially unlimited. And if you breach this duty, there are a lot of quite burdensome remedies that a court can apply to you. So one of those is a constructive trust. So for example, if someone discloses confidential information to you and you use that information to, in your business to develop a business plan or acquire assets and like accrue revenue, then a court may actually say that that property or those assets are not, you may be the legal holder of them, but you're not beneficially entitled to them. The person whose confidential information was used to acquire those assets is actually entitled to those assets, which is a very broad, burdensome thing, and it's just an important thing to be aware of. Which is why we always suggest when entering into any kind of commercial relationship or a transaction that you reduce the two parties' intentions into writing by entering into a confidentiality agreement. This can kind of impose obligations short of the common law duty and outline and provide clarity with respect to the use of confidential information in and throughout a commercial relationship. So now we're going to get into a little bit more of the content of confidentiality agreements and certain provisions and terms that are important to be aware of and keep in mind if and when you enter into one of these agreements. So these are the basic provisions and content of confidentiality agreements, which almost every confidentiality agreement you see will contain. There are other provisions that we're not going to talk about, but these are kind of the main important ones to pay attention to. Okay, so the first and probably most important aspect of any confidentiality agreement is the actual definition of confidential information in the agreement itself. This will govern what information is actually protected and is effectively the subject of the agreement. So typically what confidential information will include in its definition is all information that is communicated orally, electronically, or in writing. So pretty straightforward, but anything you say to the other party, anything electronically over email or any other means, or any hard copies of documents provided in writing. The second one is all information observed or derived from a site visit. So what that means is if one party goes to the offices or factory or warehouse of the other and observes certain information while there, any information gathered during that visit also falls within the scope of confidential information. The third one is any information derived or interpreted from an analysis relating to the evaluation of the above materials. So that can be things like business models or inputs into business models, developing strategic plans going forward with another party's confidential information. So that is still included. The fourth one is transactional information. So that would be things like the terms of any kind of transaction you are entering into with the other party, other agreements entered into pursuant to that transaction, and their terms. And then the last one, is all communications, discussions, and negotiations between their parties and their representatives. So that's effectively any communication between the parties in the scope of all of the above, and that includes the representatives such as, for example, lawyers, accountants, things like that. So these are the basic tenets of this definition, but it's really important to keep in mind that, you know, this is a highly negotiated term of these agreements often. So depending on your specific business, the industry you're in, or various other factors, you know, you can tailor this definition to what you want it to be. And, you know, you shouldn't limit the definition to these 5 things if there's some more specific definition that will suit your purposes better. So while those are kind of the main things that are included in confidential information, there's also certain carve-outs from this definition. So the definition of confidential information typically does not include information that is or becomes generally available to the public, other than through an act or omission of the party who has received the confidential information. So this, makes sense if there's some information that's communicated to you, a part of which is already publicly available, then that publicly available information is not going to be subject to the agreement. Information which was or becomes available from a source other than the party that disclosed the information, provided that it was provided by that disclosing party, and it wasn't prohibited by contractual, legal, or other obligations from being disclosed. So what that means is if another party has disclosed the same information to you, other than the other party to the agreement, then you receive that information from a different source, and that information is not subject to the agreement. Information that is in the receiving party's lawful possession prior to the date of receipt from the disclosing party. So that's information you already have, and by the disclosing party providing it to you again, it's not subject to the agreement. Any information that is independently developed by the receiving party. And while this is very hard to prove, it's technically not included within the definition of confidential information. And then finally, information that is required to be disclosed by law. So again, while this isn't kind of a set in stone part of the definition of confidential information, it can be negotiated. These are 5 carve-outs that are almost always included in that definition. So now that we have kind of defined the general idea of confidential information, there's two main types of confidentiality agreements, and it's just important to keep this in mind throughout the rest of this presentation, because this will dictate a lot of other terms. So the first one is mutual confidentiality agreements. This is probably, hopefully, pretty self-explanatory, but a mutual confidentiality agreement is where both parties to the agreement are disclosing information to each other. So they are disclosing parties, and therefore both are also receiving information. So they are mutually restricted in their use of that confidential information, which is all subject to the agreement. And then one-way confidentiality agreements. There's only one party that is the disclosing party, and then the other party is the receiving party, and the receiving party is restricted in the use of the material provided by the disclosing party subject to the agreement. So depending on what type of confidentiality agreement you have, or what kind of business relationship you have, whether both parties or just one party is providing information, this will dictate some of the other terms going forward, or at least it will dictate your negotiations of the other terms. All right, so once information, confidential information, has been disclosed to a party, what protective measures and degree of care are required by the receiving party to treat that information with? Or, when you have confidential information in your possession, what are your obligations with respect to that? So there are a few traditional variants that we see in confidentiality agreements that cover kind of a spectrum. The first being holding the confidential information in trust. This is a very stringent requirement that we generally advise avoiding because it implies a fiduciary duty. When you are in possession of confidential information, you are holding it for the benefit of another person, and it's a very high burden. The second one is to keep the information confidential, to hold it in confidence, or keep it strictly confidential. You'll often see these are all synonymous and imply that you're in possession of confidential information, something gets leaked, and therefore you are liable for that leak. It's a very high standard because there's no defense of, you imposed XYZ measures. It doesn't matter. If there's a leak, you're liable. The third one is using reasonable precautions, or sometimes you'll see commercially reasonable efforts to protect the information. This is probably more common, and if you are the receiving party, something that you would likely want to push for above the preceding one, because what it means is that if you hold information and you use reasonable precautions in protecting that, then if, say for example, your server is hacked and some of that confidential information gets out, as long as you use commercially reasonable efforts to protect it, you likely won't be found in breach of the agreement. And then the subnote there, to avoid best efforts, that's some language you might see sometimes. We often suggest avoiding that type of language because it also implies a very high standard of protection that's similar to the strictly confidential. And it's a definitional issue as well. It's hard to define. And the fourth one is treating information with the same degree of care as your own information. We also tell our clients to be careful with this type of provision because especially if you're the disclosing party, you don't want to rely on the person you're giving information to decide how to treat that information. They may not be reputable. They may not have very good data protection in place, and it's variable. Like, you have no way of determining what their practices are. And then finally, treat it with according to industry standards. This is also something that we generally recommend avoiding because there aren't really easily identifiable industry standards with respect to protective measures of data, and so it's very vague. And then the last point here is just to be cautious of overly complex identification and protective measures in the agreement itself, because if you don't treat data appropriately, or you fail to follow through with those measures that are identified, then the information may not fall within the scope of the agreement, and therefore may not have the protections of the agreement.
I think the classic example that they always point to for that is that if you say in your agreement that confidential information has to be stamped confidential or marked a certain way, and then you don't follow through with that, then the court may turn around and say, well, none of this is confidential information because you didn't follow your own agreement. So just be careful about putting too many conditions on that definition of confidential information, unless you are going to follow them.
Okay, so another important provision of these agreements that you'll often see is a restricted use clause. And so what this kind of dictates is once you have information that's identified as confidential, once you're implementing the appropriate protective measures, how are you actually allowed to use that information? So confidentiality agreements typically restrict the receiving party from using information for any purpose other than the specified purpose contemplated in the agreement. And it's very important for both parties that this is clearly stated. You know, if you are disclosing information to someone else, you want it to be very clear what they're doing with that information. And similarly, if you're the receiving party, you want to make sure that you're aware of the scope with which you're allowed to use that information. So one thing that we find is often the purpose of an agreement is kind of unclear or buried. It'll often be in the preamble to the agreement, but that definition can be actually very important. They've been generally, you know, if you have a purpose defined in your agreement, for example, you know, this agreement is entered into pursuant to the intention of the parties to enter into X kind of agreement or transaction, maybe an asset purchase, for example, then that is the purpose, and the receiving party can only use the information that is provided pursuant to the agreement related to that asset purchase. And it's important to note that restricted use clauses have been broadly interpreted by courts in Canada. So Canadian courts, there's a lot of jurisprudence and judicial decisions that have come down against the receiving party, in the sense that if the receiving party uses confidential information for something that in any way is beyond the scope of what the purpose is as defined in the agreement, then Canadian courts have been very activist in saying, you know, imposing some kind of remedy preventing that party from using or benefiting from the confidential information.
Just like a lot of these clauses in the confidentiality agreements, depending on whether you're giving or receiving the information, you may want very different things. And the restricted use clause is a perfect example of that, because if you're giving information to somebody, you want to be really certain that your restricted use clause is really specific so that they can't use that information for anything else. Whereas if you're receiving the information, you might not even want a restricted use clause. You might want to say, you know, I can use that information however I want for the, that would be the, you know, great. So it really depends on if you're giving or receiving information. But these clauses are very important to the agreement because it's how they're going to use your confidential information or how you can use that information.
Okay, so another important aspect of a confidentiality agreement are the provisions that deal with the return or destruction of confidential information. And what this means is once the contract is terminated, once your relationship with the other party ends and the term of the agreement has come to an end, what happens to the confidential information that has been provided pursuant to that agreement. So most agreements will have a provision that provides that the receiving party must return or destroy that information at the end of the agreement. And so it's important, if you're the disclosing party, that you pay attention to this, this clause very carefully. Some of them will be drafted so that you actually have to request that the information be returned or destroyed at the end of the term of the contract. And if you don't request that of the receiving party, then the obligation isn't there for them. And then if and when that is a requirement, you must put in the request, and then a good idea to have an officer certificate from the company certifying that the return and destruction was actually completed. So these clauses can actually be quite detailed, and they have specific provisions that deal with derivative information, which is information derived from the confidential information through the course of the commercial relationship. What happens if there are electronic files or backed up files on a server, and sometimes they'll list information that actually is required to be returned or destroyed. And so for electronic files and IT backup, they often have a carve out that it's reasonable to have these copies, electronic copies of the confidential information, remain on a server because it's unreasonable or too onerous to destroy them or return them. But you have to be careful, because in this case, it's important that there be an explicit obligation that the receiving party's confidentiality obligations survive the termination of the agreement. So what that means is, if the agreement ends and there's still theoretically an electronic copy on the receiving party's server, you want to make sure, as the disclosing party, that they're still obligated to keep that information confidential. And then that last point there, within the return or destruction of confidential information provisions, there's often a provision that allows the receiving party to keep a single archival copy of information. And what that means is the receiving party is allowed to keep one kind of copy or list of all the information that was received pursuant to the agreement, just so that, at a later date, if for some reason litigation occurs, they can point to, if, say, the disclosing party is claiming that the receiving party misused their confidential information, they can say, well, here's a list of all the information we've received. That information isn't within it, therefore we didn't misuse it. And similarly with the electronic backup of confidential information, you want to make sure that if there is an archival provision, that information remains, or the obligation remains to keep that information confidential as well. Okay, so the next provision that a lot of these agreements contain is a non-solicitation covenant. So this is similar to, or maybe part of, a standstill provision, which is, we're not going to talk about in this presentation because it's a whole topic in itself. But effectively, the receiving party who's receiving information may agree not to solicit or compete for the services of particular key employees of the disclosing party. So there can be exclusions for general solicitation or employees who approach the receiving party on their own initiative. So for example, if you're the receiving party and you put out a job offer, or you advertise for applicants, that's excluded. Or if the employees of the disclosing party approach the receiving party on their own volition, then that also is excluded. Canadian courts are more likely to uphold these restrictions in the context of a sale relative to the employment context. So for example, your courts are really reluctant to place restrictions on like single employees, whereas in the sale of a transaction, with respect to that specific transaction, they're more likely to uphold restrictions. And it's important with respect to these provisions to just keep in mind that reasonableness, they have to be reasonable in the context. So they should protect a legitimate proprietary interest. They should be reasonable in terms of the length of time that for which they apply, the geographic area, nature of activities prohibited, and overall fairness. And finally, they should be very clear and certain, not vague, because courts are less likely to uphold a very vague provision. Oops. All right. So the next aspect of confidentiality agreement to pay attention to, and that is quite important, is the remedies section. And what this is if someone breaches their obligations under the agreement, what are the consequences to that, or what can happen? And these are often formalized in the agreement itself and are a very important thing to pay attention to, because they'll actually dictate, what you're liable for, what the other party is liable for if one of you breaches the agreement. And so as discussed kind of at the beginning of the presentation, when it comes to confidentiality and confidential information, courts are more likely to they've taken very broad interpretations when it comes to remedies available. And so they'll often impose an injunction and not necessarily damages, like I talked about earlier with the pecuniary losses. It often, in the context of using another business's confidential information, it's not easily determinable from a monetary point of view what is the damage that you suffered. And even if it is, or there's an argument that it is, a lot of the time you'll say, this isn't sufficient. Our business is based on this proprietary information. Someone else took it and used it for their own benefit, and we can't be adequately compensated by just an award of damages. And so courts will often, in that case, impose an injunction on the party who has misused confidential information, which means, they will make the breaching party stop using that information, as opposed to waiting to go through the court system, which may take years while they continue to use that information.
Often what we see is the parties actually agreeing in the agreement that damages just won't suffice, and so they agree that an injunction would be the appropriate remedy, so that if you needed to go to court to stop somebody from using it, you would have this provision to point to where you could say, look, we both agreed that if they breach, that an injunction would be the proper remedy.
And then it's just important to pay attention, within any contract. Often you can have a choice of dispute resolution forum. And we're not going to get into too much detail on this just because it's a very complicated topic, but just something to be aware of. You know, there's options of arbitration versus the courts. You can choose arbitration and put that in to the agreement itself, but I think this is a topic for another time. Okay. And then something just to bear in mind, we alluded to earlier, but it's important that when the agreement comes to an end, whether that be, you know, initially you may say the term of this agreement is for X number of years, or, you know, after the consummation of whatever transaction is contemplated or something to that effect, that certain terms of the agreement, despite the fact that the agreement itself has terminated, should survive the termination of the agreement. And so it's just important to turn your mind to that. I mentioned earlier obligations to return or destroy confidential information. If there is any information still being held, as the disclosing party, you should ensure that the obligations to protect that information are still in place. And so, yeah.
Sorry, I was just going to say, just generally the term of the agreement, although it's a business provision and it's not something that we decide, because really that's for the client to decide, but the term of the agreement is a very important decision that the client has to make, because they need to decide, once we give you this information, how long do you need to keep it confidential for? Because once the term of the agreement has ended, essentially that information that they might know, they don't have an obligation, a lasting obligation to keep it confidential. So you really want to think about the information that you're providing to them, and think about how long you want the term of this agreement to last.
And then finally, we just wanted to point to a few other provisions that are generally found in confidentiality agreements, but we're not going to get into a lot of detail here, just because they're quite complicated legal topics, and but just something to keep in mind. All right, so that is confidentiality agreements. And now we're going to get on to the next topic, which is letters of intent. So as I said at the outset, letters of intent are also very important documents to consider when you're first entering into any kind of commercial arrangement. Sorry. And yeah, so they come in, they may include or be called various things, but effectively they perform the same function. So letters of intent, LOIs, term sheets is a common one, memorandum of understanding, aid memoir, heads of agreement, heads of terms. And so letters of intent, they are a really helpful tool when entering into any kind of transaction or commercial agreement. They help the parties focus on the big picture issues without technical legal distractions. So they help kind of establish what the main material points of your commercial arrangement are going to be. They narrow the issues, they identify potential deal breakers, consolidate the core principles of the agreement, allow parties to understand the intended material business consequences of the transaction. They specify conditions precedent to a transaction, so what needs to be done before you actually enter into a definitive agreement. And they build momentum. So these are all kind of really important things to do before you enter into an actual definitive agreement and rack up a whole bunch of legal costs and technical drafting before you've actually established kind of what you want to accomplish by entering into this this relationship. So letters of intent also signal commitment by the parties to justify allocating resources to the prospective transaction. The reliability or credibility of a party can be at issue if an LOI is too casually entered into and abandoned. So something important to note with LOIs is even though they're often not binding, legally speaking, it's really important not to distill into writing terms and conditions that you are not willing to proceed with. It's kind of, we put here in brackets, morally binding. So you should really be negotiating in good faith with a counterparty, and make sure, if you represent something to someone orally or in a non-binding letter of intent, and then later on are not actually willing to commit to that, it is not conducive to productive kind of business relationship.
It could affect the negotiations moving forward. Although it wouldn't be binding and any party could do it, you just want to be sure that what you put in your term sheet, you're ready to agree to.
Yeah. And so, letters of intent provide a strategic opportunity to reach an agreement on issues that may be contentious. In a non-binding document, they create first mover opportunity, to gain exclusive rights. They establish a preliminary timeline for an agreement, which is really important. And then something that maybe isn't as relevant to this audience, but they provide a tool for obtaining regulatory and third-party consents. So in our practice, for a lot of public companies, that's something we have to think about a lot. And so the basic content of an LOI often addresses these points. So it outlines the transaction structure. Maybe this is for example, it could be an asset purchase, it could be a share purchase, it could be a mix between these two things, it could be a financing, it could be some other kind of commercial relationship, but it will often outline the basic kind of tenets of the relationship. It will address the consideration. So what that is basically the payment or what is going to be provided under the agreement. For example, I'm selling you this asset, and you're going to pay me this much money, or it could sometimes be expressed as a range. Something that may not be as relevant to some of you, but an LOI might address the composition of management and the board of the company. So what that means is, I'm going to lend you this much money, I'm going to invest this much money, and in return, I expect to have some kind of board position or representation on the board, being able to appoint someone to the board, something like that. An LOI will often outline what the definitive agreement is that will be entered into. So in an asset purchase, it'll say, the terms of this LOI, should we choose to proceed, will be settled in the form of an asset purchase agreement, or depending on what the nature of the transaction is. So it'll outline kind of the key terms or conditions of the definitive agreement. It'll provide a high-level summary of deal protections. A break fee quantum, so if you want out of the agreement, is it going to cost you anything? Are you going to have to provide what we call a break fee if you decide that you don't want to follow through with the transaction? Treatment of options and warrants. So, for example, in a share purchase transaction, if someone is purchasing all of the issued outstanding shares of the company, what happens to any options and warrants that are outstanding? Treatment of indebtedness. If the target is in a lot of debt, what's going to happen to that debt if a share purchase goes through? Yeah. Okay. Sorry, our computer is frozen. Oh, here we go. Okay. And then just some other, these are just a list of some other things that an LOI can deal with. The most important of which is probably the legal effect of the LOI, which we're going to get into a bit on the next slide. So as mentioned earlier, there's kind of two main types of LOIs, binding and non-binding. A binding LOI contains all of the essential elements of the agreement, which may but need not be followed by a more detailed definitive agreement. This is rarely used in complicated transactions, just because a lot of the time the point of an LOI is to be more preliminary. And then that second point there is more relevant to public companies with respect to their disclosure obligations when material changes occur in their business. So we won't get into that. And then a non-binding letter of intent confirms the existing understanding of the parties, but it's not intended to create legal obligations, although it does create some limited ones, which we'll get into later. The legal obligations are intended to appear in a binding definitive agreement to be later negotiated. So the presumption is that any agreement, this is just generally speaking, is intended to create enforceable legal obligations. If that isn't the case, if you are intending to enter into a non-binding LOI, it should be very clearly stated that that is the intention, to not create binding to not create binding obligations. And it should be stated very early on in the LOI. And then it should also state that any binding obligations are conditional upon entering into a formal agreement, just for clarity. It should also state that other important matters are still to be agreed and will be agreed in a formal definitive agreement. So this is an example of a non-enforceability provision. I'm not going to read it, but this is just some sample language that may be helpful to include. And then, yeah, so it's important to ensure that the substantive content of the LOI is consistent with this non-enforceability language. And these are just a few pointers of what type of language to use to make sure that you communicate the intention that it is not a binding agreement. And then it's often desirable to specify that certain provisions of a non-binding LOI are actually intended to be binding. As I said earlier, some of them are listed below. One of the most important ones, confidentiality probably, which may or may not be included in a confidentiality agreement. But so even though other provisions of the LOI are not binding, the confidentiality provision is binding. So if any information that is disclosed pursuant to the LOI is the confidentiality obligations are binding. All right, so I think that wraps up the substantive part of our presentation.
And I think we did have one question that we just couldn't really see when we were doing, and it said, what is the first mover opportunity? And that's just really the concept of sort of the early bird gets the worm. You know, the first person to make the move, to get their agreements out, to get their terms out, to ask for things. You know, you just have an advantage by being out there, by being the first mover, by, you know, stating what you want, really. So it's just a concept. But we're happy to take any other questions that you guys might have on confidentiality agreements or letters of intent.
Great. Thank you, Michelle and Brianne. I see a question here. It says, before going to talk a lawyer, what is the information, quote unquote, questions answered that you should have ready before drafting an LOI?
Sorry, can you just repeat that again?
Before going to talk to a lawyer, what is the information or questions that you should have answered and ready before you draft the LOI? So what type of information like if somebody was coming to see you, what do they need to have ready? What type of questions are you going to ask them?
You know, it really depends on what kind of transaction you're entering into, but you want to have those big picture business terms settled. So, you know, if this was the purchase of a business, you want to be asking, well, are you buying the shares of the company or are you buying the assets? Or, you know, you might want to have sort of the timing figured out. You might want to have, you know, what's happening with the employees. It's just those bigger picture business terms that you want to have settled. Okay.
Great. And then can you distinguish between a confidentiality agreement and an NDA or a non-disclosure agreement? Like when would each be relevant, or are they similar or very different?
They're just different names for the same thing.
Okay.
Yeah, you can have a confidentiality agreement or you could have a non-disclosure agreement and they can cover the exact same thing.
Okay.
Yeah.
Great. And in the Q&A here, I see Trisha's asking, I've been setting up a small NGO and wondering if these also apply, or is there a different format? And maybe Trish, were you talking about confidentiality agreements or letters of intent or both?
Sorry, I don't know if Trish.
Yep, no, go ahead.
Yeah, generally, I mean, the same concepts are going to apply. These are both just agreements that you know, we're sort of setting out the lay of the land on these agreements, but everything can be negotiated and should be negotiated to apply to your specific business. I'm trying to think, there would probably be some additional things that you would be concerned about if you're dealing with an NGO.
Mm-hmm.
But I mean, the basic concepts of the confidentiality agreement and the LOI are going to apply. You know, you're going to want to know what information is confidential, what information is not, how it can be used. Those are all just the basic concepts.
Mm-hmm. And I actually just recently drafted a confidentiality agreement for a charity that I work with, and substantively speaking, like, it contained everything that we spoke about in our discussion. So, yeah.
Okay, great.
We just had another question with what is a NGO?
Yes.
And it's just like a not-for-profit sort of charity.
Perfect. Okay. Well, our time has run out, so thank you to Michelle and Brianne very much for all the information you gave us today. We did have a couple of questions about the going over and being able to view the slides. So I just wanted to let everybody, remind you that the presentation has been recorded. So we will send you that link as well so that you can go through this, make your notes, ask any other questions, and so forth. And then again, if there's anything else that Michelle and Brianne want to share in our follow-up email, that would be great. So thank you again, Michelle and Brianne, for sharing all this information with us. Provide excellent content and lots for everybody to consider when drafting up either a letter of intent or confidentiality agreement. And then quickly, everyone, just as well, watch for our follow-up email that will come out. We always like to get feedback on this, and then your suggestions for other topics where we can support you. And then we'll share some of the other upcoming events and series that you can participate in. So again, thank you everyone for joining us. Thank you, Michelle and Brianne. And I hope everybody enjoys the rest of their day today. So thank you everyone for joining us.
Thanks for having us.
All right, have a great day, everyone. Bye-bye.